Hi guys, welcome to the channel. Today I am dictating you 500 words legal dictation at the rate 80 word per minute. So let's get started. 3, 2, 1 and go. It is contended on behalf of the appellant that there is necessity for uniform and consistent interpretation of the phrase aid and advise used in different articles of the Constitution such as Article 74, Article 163 and Article 239 AA in the context of the functions of the President, the Governor and the Lieutenant Governor respectively. It is urged that the provisions of the Constitution, being on a higher pedestal than ordinary statutory provisions, require to be interpreted in a different manner, and in view of the same, Article 239 AA under bracket 4 deserves to be interpreted in a manner as other provisions of the Constitution, and hence there is warrant for interpreting the phrase aid and advise in a broad sense so that such aid and advise is binding on the nominee of the President, that is, the Lieutenant Governor. It would be an anathema to the constitutional philosophy to surmise that just because the Constitution permits a difference of opinion between the Lieutenant Governor and the Council of Ministers, the aid and advice tendered by the Council of Ministers is not binding upon the Lieutenant Governor. The appellant has further submitted that under Article 239 AA under bracket 4, the Government of NCT of Delhi and the Council of Ministers of NCT of Delhi have exclusive power over all matters in relation to subjects under list second bracket start excluding entries 1, 2 and 18 thereof and entries 34, 65 and 66 in so far as they apply to entries 1, 2 and 18 thereof. Bracket close. And list third of the 7th schedule. According to the appellant, the substantive part of Article 239 AA under bracket 4 itself lays down the exception to it. That is, when the Lieutenant Governor is to act in his discretion under the law and not as per the advice of the Council of Ministers. The proviso to Article 239 AA under bracket 4 as per the appellant comes into play where the aid and advice of the Council of Ministers transgresses the areas constitutionally prescribed to it, and the proviso does not allow the Lieutenant Governor to have a different view on the merits of the aid and advice that has been tendered by the Council of Ministers. According to the appellant, the proviso to Article 239 AA under bracket 4 operates only in 35 exceptional situations, and is not a general norm. Any attempt to expand the scope of the proviso beyond exceptional matters is not tenable, as it would have the effect of rendering the main part of Article 239 AA under bracket 4 to rely upon the proviso to Article 239 AA under bracket 4 to say that the aid and advice of the Council of Ministers is not binding upon the Lieutenant Governor in areas in which the Delhi Legislative Assembly has competence to legislate would defeat the purpose for which institutions necessary to operationalize democracy in Delhi were created. It is submitted by the appellant that the 1991 Act as well as the rules themselves cannot be used to interpret the constitutional provisions in as much as they only reflect the scheme of governance. Stop and over. Thanks for watching the video. गाइस वीडियो अगर अच्छी लगे तो लाइक शेयर एंड सब्सक्राइब ज़रूर कीजिएगा और साथ ही बेल आइकन को प्रेस कर दीजिएगा ताकि आपको डिक्टेशंस टाइम पर मिल सकें। एंड गाइस किसी भी वर्ड की आउटलाइन में डाउट हो तो कमेंट में पूछ लीजिएगा। वी विल रिप्लाई यू एज सून एज पॉसिबल। थैंक यू।